In this video, we're going to talk about modification of parenting time in Indiana. This is a video for a person who may have an existing custody or parenting time order through a divorce or paternity case. We're going to talk about the standard for modification, some things you should look for when you're looking to modify, as well as some things you shouldn't do. So about me, my name's Nathan Vining. I'm a family law attorney here in Indiana, and hopefully by the end of this video, you know more about how you can modify parenting time in Indiana. And the first thing we should look at is the standard for modification. Indiana Code 311742 sets out the standard, and ultimately it allows a court to enter any modification that would serve the best interest of the child, and it also sets out when a court can restrict parenting time. And a court can't restrict parenting time unless there is some evidence that the parenting time might endanger the child's physical health or significantly impair the child's emotional development. So ultimately that sets out the standard, and what we have here is another best interest kind of argument. So the process to modify is actually pretty simple, but how it plays out can be complicated because ultimately it depends on the kind of evidence you have to present, what kind of resistance you meet, and it's something you have to prepare for. So ultimately the first thing to do is consult with an attorney. From there you would draft the petition to modify. You would file that with the court, serve it on the other party, and the process varies county to county in Indiana, but the typical process would be that you would have some sort of preliminary hearing where the court would hear evidence on the petition and make some preliminary orders. They then typically would order you to mediation, and then from there you either settle the case or you would go to a final hearing. The final hearing is a longer hearing. It's typically a half or full day hearing where the court would hear evidence about the case. They would hear from multiple witnesses and ultimately would make a decision according to the best interest of the child. And again, it varies county to county. Some counties may hold that final hearing initially and they would just set it for a 2 to 3 hour hearing where you would go and present evidence. Others, you may have a shorter hearing, mediation, then a final hearing. It just depends on where you are, and an attorney can give you an idea on what to expect in your jurisdiction. So we talk a lot about best interests in Indiana family law cases, and it can mean a lot of things, but Indiana Code 311728 sets out the best interest factors, and there's a lot of things. It's things like the age and sex of the child. For instance, if it's a younger child, a lot of times the father may have a harder time getting more substantial parenting time when a child's under 3, but that doesn't mean it's not possible. It just depends on the facts of the situation. You would look at the wishes of the child's parents. You also would look at things like the interaction and relationship with the child, their significant others, other people who impact the children, as well as the child's adjustment to the community. So a lot of times in a custody case, there's a lot of basic things that I would bring out in evidence for my client. A lot of it would be just basically laying out what a day in their life looks like. When do you wake up? What do you do for breakfast for the child? When do you go to work? How do you get the child to school? And then from there, what do you do when there's issues? How do you discipline the child? What kind of things do you do together? In your community, does the child have friends in the neighborhood or friends that come over, cousins, grandparents? We talk about all that kind of stuff to build a big picture to show what is going on in your situation, to show why the relationship with you is a beneficial relationship. And a lot of times when you're a parent that's looking to expand their parenting time, it's important to show how beneficial of a relationship it is when they're having parenting time with you, to show that there's all these good things going on, that the court actually in fact should expand that time. So it's a lot about showing the history of your relationship with the child as well as what's going on. Other times there may be specific things going on in your case that also justify a modification. There could be issues with parenting time. For instance, you're not getting all the parenting time you're supposed to be getting. There could be a lot of conflict. There could be concerns in the other parent's home. So a lot of the evidence would be talking about those things as well. So ultimately, parenting time modifications can go a couple ways. It could be one parent looking to increase their time, or it could be you looking to reduce the other parent's time. This is really about reducing a parenting time order. A lot of times if the court's going to reduce a parenting time order, some common things you may see would be the court looking at substance abuse issues. There could be stability issues. A lot of times maybe a parent has moved multiple times within a school year, and there could be issues with child school attendance, or their grades are slipping because they've changed schools multiple times, or it's just not the best home environment because they've moved quite a bit and there's maybe a lot of people there, things such as that. There could be health concerns, and then also there could be behavior problems. Maybe there's a history of behavior problems at school following a parenting time at one of the other parents' houses, things like that. Ultimately, evidence for reduction of parenting time can be broad. These are just a couple examples of what we would maybe commonly see in this kind of case. When you're looking to increase parenting time, there's also a lot of things you would look to do. One big thing is proximity to the other parent. It's a lot of it can be very hard to expand parenting time if you live a couple hours away. It's hard to get that weekday parenting time if you are far away and the child's in school. So if you're looking to increase your parenting time, one of the first things you should do is try and get in close proximity with other parents so you're in a good situation where you can co-parent. And then that goes to the next point, encouraging the co-parenting relationship. I always tell people it can be very frustrating dealing with an ex or somebody who you may not work the best with. A lot of times you end up here through a divorce. It means that there's probably some pattern of poor communication where you guys just don't get along. Hopefully that's not the case, but a lot of times you have to be the bigger person and suck things up for the benefit of your child and encourage that co-parent relationship. The court will see if you're out there being the bigger person. Another big thing is being involved in school activities. Know who your teachers are, know when parent-teacher conferences are. If there's an individualized education plan, take part in those meetings. If you're coming to court and asking for more time, the court's going to want to see that you're taking advantage of all the opportunities that are there for you anyway. And according to Indiana law, if you're the non-custodial parent, you have a right to all the school information. So you might as well take part and get access to all of that. Another issue could be too many parenting time transitions. Sometimes people get set in a schedule where there's 2 to 3 exchanges per week, and that gets hard on a child as they age. Sometimes you may be able to go to court and show that a change is needed just based on how it's practically working out over time. And then there's also concerns with the other parent. Maybe there's some issues going on. You're being denied parenting time. Maybe something's not adding up in their house. There's substance abuse issues. Those would be some things that you would look to if you're looking to increase your parenting time. And then last, supervised parenting time. Sometimes there's big concerns such as major drug abuse, domestic violence, things like that. And if there are those things, ultimately the court would find that is something that impairs the child's well-being, either physically or mentally, and the court would enter an order for supervised parenting time in that instance. And how that works is there's a lot of supervised agencies around Indiana where you would go there and there would be a supervisor and the parenting time would take place in a structured facility. Other times you actually can hire a supervisor to do community visits, or the parties can agree to a third party who they trust who could be the supervisor. So it can work out a lot of ways, but ultimately there has to be that endangerment factor for the courts to order supervised parenting time. Another big issue with parenting time orders is enforcing parenting time. One of the biggest calls we get is somebody that's maybe has a parenting time order, but they're not getting their parenting time order. One of the things you can do there is file a motion for rule to show cause or a motion for contempt. And ultimately what you're doing is saying there's this court order that sets out a parenting time schedule and the other parents not following it, and we need the court to intervene to make sure things are being followed. And that's, I spoke to parenting time but it can be broader. It can be things like not getting phone access, not getting not getting medical school information exchanged. It can be all sorts of things, but ultimately contempt is a very big tool in family law in Indiana, and it can be used to help get the order working correctly. And a lot of times when you have a contempt finding, the court will hold review hearings from time to make sure things start working correctly in the way the court ordered, in a way that they see as in the best interest of the child. So another big thing with these cases is documentation. A lot of times you get a client that hires you and they say these things are happening, but they lacked documentation. So something I recommend in every family law case is to get a journal and keep good records. So you can say, if you miss parenting time, how many times it was missed in the last year, what was the communication around it, and have all that kind of stuff saved. So you can be very specific as you're building your case. It's better to be specific and give the judge too much information and too much detail, or at least to give your attorney that, so that they can pick out what's the most relevant to build your case around. So ultimately, if you're looking to increase parenting time or decrease parenting time or change parenting time order, that is the kind of thing we can help with, and I'd be happy to review your situation and answer any questions you have.